では、動画の2、調停手続きについて、解説をいたします。ここでは、調停の特徴、メリット、進め方についてご説明をいたします。調停、メディエーションとは、当事者間の紛争について、公正独立の第三者、すなわち調停人が入って、調停人の仲介の下で、当事者が交渉して協調的な解決をする手続きです。国際仲裁は、仲裁人が強制力のある判断を下すのに対して、調停は双方の合意で解決策を固めるため、まとまりさえすれば両者が納得しやすいという特徴があります。過去の法的な論点だけではなくて、両当事者の共通のインタレストを追求し、両者にとってウィンウィンの解決を追求するという特徴があります。また、調停では一方が不服であれば合意はできず、また、調停人の和解案などにも拘束力はありません。この点、仲裁が仲裁判断に拘束力があることと大きく異なります。また、やり手の調停人が仕切る場合、国際調停の合意率は8割から9割と言われておりまして、日経新聞で私がコメントをしたこともございます。調停と仲裁は組み合わせた手続きが用いられることも多いです。まず、メッドアーブ、すなわちメディエーションとアービトレーションの組み合わせ。当事者は、まずは調停による解決を試みて、調停によって和解合意が成立しない場合には仲裁を開始すると。調停が成立した場合には費用や時間の節約になって、調停が成立しない場合には拘束的な手続きである仲裁に移行する、という手続きです。次に、アーブメッドアーブと言われるもので、アービトレーション、メディエーション、それからまたアービトレーションに戻るというものですね。これは、当事者は仲裁の申し立て直後に、紛争を調停機関に移行して調停を試みるものです。調停によって和解合意が成立した場合には、和解合意の内容をコンセントアウォードとすることもあります。和解合意が成立しない場合には仲裁手続きに戻ります。このコンセントアウォードのところについては、シンガポール条約の加盟国においては、コンセントアウォードになくても、国際調停の効力が認められるということになります。次に、調停人の選任について。これは基本的には当事者の合意、または、合意が成立しなければ機関による選任ということになります。ICC の調停規則では、当事者はセンターによる確認を条件として共同で調停人の指名をすることができます。また、当事者の共同での調停人の指名がない場合、センターは当事者と協議の上、調停人を選任するか、または当事者に調停人のリストを提示することができます。センターによる確認を条件として、すべての当事者はかかるリストの中から共同での調停人の指名することができるんですけれども、こういう共同での指名がない場合には、センターが調停人を選任するものという規則になっています。また、調停人と仲裁人が同一の人物でよいか、兼任できるかという点については、当事者間での明示的な合意が必要とされることが多く、ICC の調停規則では、調停人は本規則の下での審理のいかなる点についても裁判、仲裁、または同様の審理において証言をしてはならない。ただし、すべての当事者及び調停人間での書面による別段の合意がある場合や準拠法で必要とされている場合はその限りでないという定めがあります。また、兼任については、大陸法権では、調停人と仲裁人の兼任は効率化に資すると考える傾向がある。つまり、是と考えられるに対して、英米法権では、調停人が仲裁人を兼ねることについては、調停において自由な発言が制約されるという考え方から、どちらかというと、非というふうに考えられる傾向があります。調停手続きの進め方について、まず、調停手続きにおいては、調停人と当事者間で手続きの進め方を合意して、その上で当事者が書面で主張内容を説明した上で、通常ですと1日から数日にわたる期日を設定して集中的な審理を行います。調停期日は双方当事者が同席するジョイントセッションと、調停人と片方当事者だけで議論するプライベートセッション、包括セッションとも呼ぶことがありますが、これを交えて組み合わせて行います。方法としては、ファシリテイティブ、つまり促進型、交渉援助型的なですね、方法と、エバリュエイティブ、つまり評価を下しながら進めていくというものがあります。また、両者を組み合わせた方式も用いられます。コモンローとシビルロー、大陸法権のハイブリッドの形、 そしてその文化的背景への配慮に基づくコミュニケーション、こういうものが重要になってくるのが国際調停の現場と言えます。調停手続きの進め方について、調停は非公開かつ秘密性を持って行われて、調停で示された提案などは、後の仲裁などの証拠として用いてはならない。これは without prejudice という、観念なんですけども、そういうことが言われます。また、秘密性については、世間に対して公開をしないという秘密性。それから、一方当事者との協議、ディスカッションについては、相手の当事者には言わない。これがプライベートセッション、広角セッションの特徴ですけども、そういう秘密性。それから、ここのwithout prejudice、仲裁などの証拠として後に用いてはならないという3側面があります。ここに ICC 仲裁規則を一応参照までに記載しておきました。事案の概要として、仲裁準備会後の進展ですね。この後見ていただくビデオについて解説しますと、仲裁準備会の最後にセルモーター社から本件について調停に付す旨の提案がされました。準備会の終了後、セルモーター及びオートソフトは当事者間で話し合いの機会を持って、仲裁手続きは中断したまま、まずは調停を通して解決を図るという合意をしました。ここは、動画1の解説でも述べたように、双方弱みもあるということ、それからウィンウィンの解決を目指すということを考慮して、まずは話し合うというプロセスについて合意したというふうに、想定しています。両者はアドホック調停によって和解交渉を行うことで合意し、共同で第三調停人を示しました。規則として ICC 調停規則を利用しながらアドホックとして行う。また、場所としては京都国際調停センターを利用することに合意したという想定にしております。こういう想定のもとに調停が始まりますので、動画をご覧ください。
Welcome, everyone. Welcome, ladies and gentlemen, on the stage. Welcome to our mediation between Autosoft Corporation of Silicon Valley, United States, and Cell Motor Inc. of Tokyo, Japan. Why are we here for this mediation? The answer is because you have decided, after an intense procedural arbitration hearing, after having heard the decision by the arbitrators on two important procedural issues, for the time being, not to pursue the arbitration, but try to resolve your dispute in a slightly different matter. Whether it's slightly different or different, that remains to be seen. At least the arbitration is stayed. And we are here to try something else. Why are we meeting in Kyoto? Because I understand you discussed this possibility at the procedural hearing. And the answer is again the same, because you decided to go to Kyoto to avail yourself of the services of the Japan International Mediation Center in Kyoto, newly launched. In fact, I believe this is the first mediation supported by the Japan International Mediation Center under the auspices of this new organization, which was set up, I understand, with the support both of the Japanese government and the Japan Association of Arbitrators, JAA. We are very grateful, in particular I'm as the mediator, very grateful for also the support of Doshisha University here in Kyoto. We are using the conference rooms and the facilities. We are using one mediation room where we are right now, and we have two separate breakout rooms which you have used and we will use as we go forward. The Japan International Mediation Center is in the process of being set up. We found out that this organization does not have yet mediation rules, but we are flexible, creative, and inventive. So we decided to use, for the time being, the existing rules of the ICC, the 2014 mediation rules of the ICC, just to have a regulatory framework for the conduct of the mediation. I understand that before too long, in the near future, there will be proper mediation rules promulgated by the JIMC Kyoto. So that's the background, which I thought was important just to summarize. I personally, as a mediator, I like to travel to Kyoto. I had been here in Kyoto before. I have fond memories. It is, I believe, a very appropriate place for mediation. If I compare Kyoto with Tokyo, where I was a few days ago, Tokyo is a vibrant city. Kyoto has his special charm. It's also vibrant, an important city. It's the old capital. This provides for an atmosphere with the historic buildings, which should help us. Sometimes one hears a discussion, why is Hawaii so successful as a mediation center? Because it's a different environment, and so is Kyoto. I believe Kyoto is at least as attractive as a mediation environment as Hawaii is. And I heard when I prepared for this session that the Japan International Mediation Center is even trying to, so that I still had the translation. I heard that the Mediation Center is in the process of finding a temple here in Kyoto, which would be an even more appropriate setting for a mediation. Then we can perhaps, or we could, if that was found, have not only mediation, but meditation at the same time. Of course, that is yet another story. So here we are. Let me briefly introduce myself. I'm your mediator, Siegfried Elsing. I'm a German lawyer practicing in Düsseldorf. I'm also a member of the New York Bar. I'm no expert in the automotive industry. I'm no expert in patent law. I started out as a corporate attorney, and then I developed a practice in dispute resolution as counsel, as some of you are, so I know exactly your situation, your position. As arbitrator, so I have some idea of what the arbitral tribunal was doing, and as mediator. I was chair of the Mediation Commission of the International Bar Association and also served as conciliator on the list of the president of the World Bank at ICSID in Washington. Now, you jointly nominated me, and I thank you very much for the trust and confidence. Would you be so kind to introduce yourselves just for purposes of this mediation? I start with Ottosoft, Mr. Chaskis. Could you do that? Please introduce your team briefly.
My pleasure. So I'm Alex Chachkis. I am a patent litigator of over 20 years standing from the law firm of Orrick Harrington. And with me is Vanessa Laborio. And also with me is the client, James Atkins, who represents Autosoft.
Thank you very much. Mr. Atkins, you are the client, obviously the most important part of the team. Can I ask you, do you have power to settle? Do you have limitations? Can we work together with a view to implement the results of our work? Do you have power to settle?
Yes, I have full authority to settle here today.
Full authority to settle. That's important. Thank you very much. And I noted that you have a very international team. Ms. Laborio is from Geneva. So you will bring to this exercise the civil law, the civilian view. Mr. Chakis, you are a common law attorney from New York. I think that is very important because this is an international dispute, and the parties in dispute, an American company, the contract is governed, as I understand, by the law of state of California. So that's a common law jurisdiction, and it's important to have both views because, on the other hand, we have a Japanese party, civil law country. Now turning to Salmoto, Mr. Ishiki, could you be so kind and introduce the team?
This is Kazi Ishiki, the counsel for Salmotor. To my left, my partner Shinya Kura, and here we have from the Salmotor in-house legal department, Ms. Haruka Matsumoto.
Thank you very much. Mr. Ishiki, I know that you also have a very international background. You spent some time in the United States. And I remember meeting you personally in Düsseldorf on the occasion of a wonderful reception on the occasion of the Emperor's birthday, which was, of course, not held on 23 December, but as I remember, a few weeks later in Düsseldorf. We, however, as I disclosed and you accepted, only had a social contact, and I'm very happy to see you again. Now, what is the purpose of our mediation? Well, to try to settle the case. What is my role as mediator? I'm a service provider. I'm here to assist you, to help you to develop ideas, but the task, the objective, is something that you have to achieve. I will not decide the case. That's a big difference between mediation and arbitration, and I will come back to that. It is very important that we work together in a collaborative spirit. And I think because while you have a dispute, you have a problem which has quite a significant economic impact. I understand that. But you are in a long-term relationship. And in my experience, long-term relationships are very apt for mediations because the parties have worked in the past together, and they typically have an interest to continue working together. They would typically like to do that, but for the conflict, but for the dispute. And we should make an effort that we overcome that hurdle. And if we are not successful, well, you have to go back to arbitration. That's, if you like, the fallback position. Everything that is said in this mediation will be confidential. That's very important. You should be free to discuss views. You should be free to make admissions, to concede points, something that you, I say as in my role as counsel sometimes, now I'm a mediator, you would not do in an arbitration. It's different here. You can do that, and if you do this, it cannot be used against you in the arbitration in case we are not successful. Do you understand that? Will you comply with that very, very important rule? I turn to Salmoto. Thank you very much. And that also does not only apply to the words spoken, to our discussions, but also to documents that might be produced or exchanged in the course of this meeting. Thank you very much. I come back for a moment to my role. I'm not an evaluator. I will not finally say that's bad or that's wrong. That's a good argument or a bad argument. I'm a facilitator. And when I discuss later on with you the framework of the dispute, which is of course legal, and I give you some points to consider, it's not in an evaluative function. It's very important. I want to give you food for thought. I want to help you to better understand the pros and cons, the strong and the weak points of your respective position. It's very important for me to make this clear at the beginning. Yeah? I will not say that's wrong, that's right, and you will eventually prevail. No. It's just to help you to better assess and understand your situation. So, no decision. Again, since you are coming from an arbitration, just let me summarize the 4 points that, in my view, describe the difference between what we are doing now and what you have been doing in the arbitration. First of all, very important, no decision. You did not delegate the decision-making function to me. By contrast, you will make the decision. And I asked you whether you have authority to settle. I should, at this point, also ask Ms. Matsumoto, do you have authority to settle in case we discover common ground?
Yes, I also have an authority to execute any agreement between us.
Thank you very much. Second point, it's a collaborative exercise. Unlike in an arbitration, I'm sorry. There can be ex parte meetings. I will meet with you in a separate room. In an arbitration, that would never happen. I will make myself a little bit of a shuttle diplomat. I will go and talk to one side, and then I come back, and hopefully I have something to report and something to offer. It's not my personal offer, I just forward this. So, collaborative. Second, you retain the decision-making power. Third and fourth, our process is very flexible. That's also important. You decide the way going forward. I only make suggestions. We have the ICC rules, which give some framework, but basically confirm the flexibility. That is also very important. Now, having mentioned the flexibility, that does not mean that we will not proceed in accordance with a defined structure. I have issued a written note pursuant to Article 7 of the ICC mediation rules before this meeting, in which I suggested the following structure. We will have opening statements. We will have a summary of your respective position, and we will start with Autosoft. Autosoft is not the claimant in the arbitration, but the plaintiff in the Texas litigation, and Autosoft is the one which started the dispute. That's why I suggested that you begin with the opening statement, and then we have Cell Motors opening statements. Following that, we will have 2 rounds of separate meetings, caucus meetings, where we try to assess risks and opportunities, and try to find a way how you could get out of this difficult situation. And then we see what happens during these 2 rounds. Are we still in agreement with this modus procedendi, with this way to proceed? Yes. Mr. Chakis, Mr. Ishki, yes. Well, why don't you start then with your opening statement? And this is not on the procedural issues that were discussed, as I know, in the arbitration. This is about the substantive issues of the matter. Mr. Chakis.
Thank you, Mr. Elsing. So from Autosoft's perspective, I wanted to talk about 2 things. One is how important this intellectual property is to the company, and how important this mediation, and how important the arbitration and the litigation is to the company, and our perspective in that respect. And then I also wanted to talk about the merits of the litigation, not too deeply, because I know we're not here to decide the merits, but I do want to talk about why we believe ourselves to be in a strong position And any settlement or mediation would have to take into account our belief that we are in a strong position. First, AutoSoft was founded in Silicon Valley to create technology for self-driving automobiles. So the core of our business, the essence of our business, is our patents and our know-how. Of course, we also have our automated driving systems, actual physical products that we produce, but at their core are our technology. And the reasons why our automated driving systems have value is our technology, which we believe to be some of the most advanced technology for self-driving cars and automated systems. So in 2010, when we decided to talk to Cell Motor, this was a milestone moment for the company. This was the company becoming validated. It was how we were going to roadmap into our future. This was an extremely important moment in the company's history. And when we went into the negotiation, we had many things that we were flexible about. We were flexible about the price. We wanted $150 per unit. They wanted $100 per unit. And eventually we negotiated and conceded to Cell Motors' demands. But one thing never changed throughout the discussions in 2010. When we negotiated that license, we were insistent that the money would be based on the number of units that were going to be licensed. Whether it was a running royalty based on actual units or a projection, which is what we eventually agreed on, we wanted to make sure that we got a royalty per unit, per car that used our technology. And at that time when we sat down, we agreed what we would do to make the negotiation easier and to make the contract easier to administer is we would agree on a projection. The number of cars that we believed, that both parties believed, Cell Motor would be making in the future. And the number was 100,000 a year. We extrapolated that. We said 100,000 a year for 10 years, that's $1 million times $100 per unit. And that was the essence, and that was the core of the negotiation. How many units in the future? In 2010, Cell Motor only made gasoline-powered vehicles. At that time, that was the basis of our conversation. We knew Cell Motor was only making gasoline-powered vehicles. Yet, what Cell Motor didn't tell us in 2010, and why we feel betrayed and a little bit angry, is that we believe they were investigating electric-powered cars. This is something they never told us in 2010, even though they could have told us. It's our belief that in 2010, Cell Motor was looking to expand into the electric car market, a market that potentially could be much more lucrative and much better for them, as it ended up being, than the gasoline-powered market. Again, something Cell Motor never disclosed to us in 2010. And one of the reasons why in the arbitration we are so hotly disputing the documents that they want to call privileged is we believe those documents show they were talking about electric cars back in 2010. So again, we think if we went back to the arbitration, this is something we could prove. So I say this so you understand, and the client is here, why we feel angry, a bit cheated, and if we engage in some sort of settlement discussion, it has to take into account the feeling that we weren't dealt with in a straightforward matter by Cell Motor. The other thing we wanted to talk about shortly, because I know this can't be resolved here, but our belief that on the merits, we have an extremely strong case. We have two separate and distinct grounds that are the core of our arguments in the arbitration. First, we believe we were fraudulently induced into the contract. So putting aside the terms of the contract, ignoring the terms of the contract, we don't think we ever would have gotten into the contract if Cell Motor had been honest with us back in 2010. And so we believe that the arbitration would show that we were fraudulently induced into the contract, and the remedy for fraudulent inducement into a contract is that the contract is no more, and that we receive the unjust enrichment that Cell Motor would have got from having a contract which clearly was based on a discussion about only gasoline-powered vehicles. Second, we believe we have a strong case on the contract. The contract is governed by California law. In California law, unlike many jurisdictions in many countries, California law looks to the extrinsic evidence outside the contract. So the negotiation circumstances, the internal documents on both sides, it looks to external documents. And I believe in that context, a court should interpret the contract as covering only gasoline-powered vehicles, which was the only subject matter of our discussion. So again, we have this separate and second claim, which we believe is a strong claim. So when we go forward into this mediation, we ask that both of these considerations be taken into account, both that the way we feel about this case, the way we feel we were misrepresented to, and that we have a strong case on the merits.
Thank you, Mr. Checkers. Before I invite Cell Motor to summarize their position, let me just confirm one point. You talked about the software, and I understand that your client also is in the business of making hardware, manufacturing devices that use the software. Is that correct?
That is correct, and that in the future may be a very important part of our business.
You are interested in developing that part of the business further.
Correct.
Yeah.
Correct.
Mr. Atkins, can you confirm that? Okay. Thank you. I read it somewhere in the file, and I thought it might have some significance. Okay. Yes. Cell Motor.
Thank you, Mr. Elsing. It is very clear that the agreement covers both gasoline cars and electric cars. The definition of the licensed products simply states any motor vehicle without making any distinction between types of motor vehicles such as gasoline cars or electric cars. It clearly covers both types of cars. Electric cars have a motor just as gasoline cars do. However, Autosoft argues that we were intentionally concealing our project to develop battery for cars, but it is not true. In fact, that project was strictly confidential. Also, there was no guarantee that the project would be eventually successful. It is also important to point out that the fact that Cellco was Cell Motors' subsidiary and that Cellco manufactured batteries, those facts were all public information. Autosoft could and should have anticipated the possibility of Cell Motor manufacturing electric cars. Autosoft did assume that risk. In fact, we were also taking the risk by agreeing to a lump sum payment of $10 million every year, regardless of how many cars we sell. Even if our sales of cars dropped by 50%, we still had the obligation to pay $10 million to Autosoft. We did take that risk. It is not fair that all of a sudden Autosoft can ask for more money just because we are selling more cars. Thank you very much.
Thank you, Councillor, and thank you both. I must say, as a mediator, your opening statements were very much like in an arbitration. You argued the legal points, understandably, because that's your mindset as counsel. But we are here not in an arbitration. We have to change your mindset. If we continue arguing about extrinsic evidence in the interpretation of contracts under California law, I don't think we make progress in this mediation concept. I should perhaps, when I gave you the differences between mediation and arbitration, I should have emphasized that more strongly. The different mindset. We don't look at positions, at legal positions, where the answer often is yes or no. We look at interests, the real interests, the economic interests. And in the context of the interest, of course, money plays a role, economic significance, but emotions, nobody can tell me that in business where you make hard decisions, pragmatic decisions, emotions don't play a role. They are also part of the interest analysis. So in light of this, let me just briefly summarize, and then we go to the interest, and I have some ideas for settlement. Let me summarize the 3 points of disagreement. Number 1 is the difference regarding the contractual interpretation. Does the agreement only cover gasoline-fueled vehicles, and I will call them gasoline vehicles in the future, or does it also refer to electric-powered vehicles, electric vehicles? Number 1. Number 2 was the lump sum that I heard about, the 10 million per year, calculated by reference only to the projected sales by Cell Motor of gas vehicles. Was that the only idea that you had? The 100,000? Very important. What was the calculation, the underlying assumption for the calculation of the lump sum fee, which, as I heard from you, resulted in some risk? 10 million. If you had sold less than 100,000, that would have been your risk. I heard you saying that. I'm not an adjudicator. I'm not saying that that is that's what I heard you saying. So that's the number 2. And the third issue is the bad faith argument, the betrayal, the fraud. This is very tough language, I must say. Did Cell Motor intentionally conceal that it was developing battery technologies for vehicles and that it was considering the possibility of manufacturing electric vehicles when the agreement was entered in 2010? Is that, in my words, in a nutshell, the essence of the dispute?
I think that's a fair way to put it, yeah.
Fair way to put it? Yeah. Thank you very much. I'm glad I understood this. Now, in the vein, going forward with the interest analysis, looking at what your interests might be, I clearly have the impression, Autosoft, from what I heard from you, Mr. Checkers, you would like to, at the end of the day, be in a position not only to put your mind as counsel, but to put the mind of your client at rest because you feel betrayed. You feel be taken for a ride. You have the impression there should have been a more open attitude. I heard you describing the efforts that your client made in developing the technology, and you have an economic interest to maximize the return on investment. You accepted a lump sum based on assumption, as you say, in 2010. Now you say it's not 100,000, it's 1 million, and more to come. And you get still the lump sum. I can see that that might be something that is very important for you as part of your interest. Is that correct? Yeah. And the additional aspect, you say you want to further develop the hardware business. You also said that that is an economic interest which is very important for your client going forward, correct? Now, turning to you, to the Cell Motor side, you are very successful as a car maker. Enormous increase in the volume of vehicles. You moved into a new area, a new market with the electric cars. And 1 million compared with 100,000, that's quite an achievement, I must say. And there's, the trajectory is still indicating that there is a further increase. And now you are faced with the risk. If an injunction is issued, that's the relief sought in the Texas court, that's also the counterclaim in the arbitration, that you might have to stop using the technology, at least with regard to the electric cars. You certainly don't want that to happen, because it would disrupt the business. It would be, could have, if the attack would be successful, disastrous consequences. Is that correct? Yeah. And then you are faced with the accusation of having been dishonest. That I can imagine, in particular, it would be a problem for any company, legitimate company, credible company around the world. But in particular for a Japanese company, that is an accusation very difficult to live with. Is that correct? Yeah. It's a bad face, losing face argument. And you want that to be cleared? Yeah, okay. I'm glad because in preparation I tried to put myself in your respective positions, in your respective shoes, so to speak, and I'm glad that I got that right. Now, what are the options? It is clear, I think, to everybody in the room that there will be no settlement if you are not willing to make concessions, if you are not willing to compromise. It's not a zero-sum game, one or nothing, all or nothing. And in the context of the search for a compromise, I believe 3 aspects might be relevant. I think they are relevant. After I heard the confirmation of what your interests are. Number 1 is monetary compensation. You want more money for the use of the technology. That's clearly what you want. Number 2, and you don't want to pay that, but you realize perhaps that at the development with regard to electric cars been on the table in 2010, the royalty would be different. So money, monetary compensation. Number 2, timing. If the injunction would be, the motion for an injunction would be successful, that would mean an immediate stoppage of your right, if you had a right, of your possibility of your use of the technology with regard to electric cars. And there is also perhaps an interest on your side to continue the cooperation. The existing license agreement comes to an end in 2020. That's already in 2 years. And your perspective for the development of the business of your company goes beyond that. So basically what a license agreement does is you purchase freedom from suit. You use the technology and you must not fear that you are being sued for infringement. You might have an interest to continue that. So timing aspect. And then perhaps there is an opportunity to bring into this mediation aspects that are not the subject of the litigation in Texas and the arbitration. New things that could not be resolved in the arbitration with regard to the future cooperation. So 3 points: money, time, and future cooperation. Does that sound like an interest analysis in the search for solution which we could build on? Yes. Yeah? Oh, I'm glad you're following me. Okay, good. Well, then I would then suggest that you retire for a moment. Just for the audience, we don't have 2 separate rooms, so we pretend to have 2 separate rooms. I, as mediator, don't normally stay in the room and have the parties come to me. I go to the parties and talk to them. So we are now in the separate room for with Autosoft. Yeah, here we are.
Here we are.
Everything is confidential, and I understand your interests. I have to come back for a moment in order to give you perhaps a better possibility to assess your risks to the legal arguments. Your, as I understand it, core argument is that the agreement is limited to gasoline cars, correct?
Yes.
But if I look at the agreement, where is that written? It says, on the contrary, any vehicle. And I'm not a native speaker in English, but if I have some understanding of the English language, any vehicle means any vehicle, whether it's a gasoline-driven car or electric car. Isn't that a problem for you?
So in the privacy
if you continue the arbitration?
In the privacy of this room where Cellmotor can't hear this, we agree. We understand that our contract argument may not be the best contract argument. We wish we had a stronger argument, correct. That does not mean we're not without some hope that we could prevail in this argument, given the nature of California law. And we also, of course, have the other arguments, which we very well could prevail on. And if we do have a chance in the Eastern District of Texas to win an injunction, that, of course, would be a game changer. So there's a lot of pieces here, not just the contract piece. But to answer your question, in the privacy of this room, yes, we understand that the contract argument may not be the strongest.
So I hear you saying you agree that this is somewhat of an uphill battle.
Somewhat, but the stakes are large, and I believe Cellmotor knows that. So I do believe we do have a good deal of leverage.
Yeah, I'm very glad that we can develop realistic views, and this is in the privacy of this room, of course. The other comment I wanted to make, you accuse Cellmotor of fraud, intentional concealment. It seems to me that that is something very difficult to prove, in particular in view of the decision, or it's not a decision yet, the position the tribunal has taken, that they want to postpone decisions regarding the attorney-client privilege. So they might, with regard to some aspect, uphold the attorney-client privilege. So isn't that a risk? Is that something you shouldn't?
Undisputably, that is a risk. We did not understand the tribunal to have ruled on the merits of any particular document, whether it's privileged or not. We are optimistic that in the arbitration, we will find documents that confirm this theory. But again, I frankly concede that there is a risk here, because anytime in any case you try to prove intent, what somebody was thinking, it's a very difficult thing to do, but that doesn't mean we couldn't do it.
Thank you. Well, now, think of the 3 points I made with regard to the interest. Money, monetary compensation, and obviously you want a lot of money, and timing. Let's leave the third aspect aside for a moment. And you have to compromise. If you say we want the damages which you calculate are the unjust enrichment compensation, there will be no settlement. You would have, I'm sorry, you would have to go back to arbitration. Is there room for maneuver? What could I, on your behalf, tell Cellmotor?
So there is some room for maneuvering. We have spoken amongst ourselves, and we do have an offer. Keep in mind that this is the core of our company. This is the licensing, the core technology. This is our biggest licensee. What we propose is that Cellmotor pays $100 per electric vehicle that uses Autosoft's patents.
Let me just write this down, because it's very important that I correctly understand your proposal. So $100 per unit for electric cars.
Yes, correct.
Use of technology in electric cars.
Correct.
Per unit, okay.
But we do believe they should stop practicing our technology. So it would be for past vehicles.
Immediately?
Well, that is our position.
Okay, I will not comment on that, but if that's your position, I just have to take it. How about gasoline-fueled, gasoline cars? We're talking about electric cars, right?
That's electric cars. We believe
2 layers of
yes, and we believe the current agreements would cover the gasoline cars up to 2020, so that aspect would not change. This would really be about what we believe to be the infringing electric vehicles that have already been sold.
So the existing agreement would stay valid, would stay in place until 2020. For electric use of technology in electric cars, you would expect $100 per unit royalty.
Correct.
And you would expect that the use of the technology be stopped immediately and no renewal of the existing agreement beyond 2020.
That is our opening offer.
Let me ask you, why should Cell Motor accept that? They will ask me, and through me you, what is in it for us? Isn't that exactly what you are trying to obtain in the arbitration and in the litigation?
Well, we believe in the arbitration and in the litigation that we could get more. So, for example, if we were to win our argument about fraudulent inducements, that would mean the contract would be, there would be a rescission, meaning the contract would be undone, and we would be entitled to unjust enrichment, meaning not just the $100 per car, but the value to Autosoft, a value to Cell Motor of having taken our technology, which is far more than $100 per car. And that's a risk that would be partially alleviated by this offer.
So you're saying in accepting this proposal, Cell Motor would have to accept your request that the use of the technology be stopped immediately, no renewal, but would limit the financial exposure.
Correct.
Thank you. I understand. I hear what you say. It might not be enough, but as a starting point, I thank you very much. This is a constructive effort, and I try to discuss that now. No, I will not try. I will discuss it with Cell Motor. Can we switch
Thank you.
The scenario? So I discussed settlement options with Aquasoft. And I have some good news and some perhaps not so good news. But before I report their offer, the good news is that they have made an offer, which is a concession in my view as well. But it might not be enough, I told them this, but we have to work together to see where we can go. But before we do that, let me just make 2 points with regard to help you to better assess the risks and chances of your argument. You heavily rely on the language of the agreement. You say any vehicle means any vehicle. It includes electric cars as well. Is that correct? And you say the 10 million lump sum covers this as well.
That is correct.
So you said we had a 10 million that perhaps was not discussed at the time. 10 million was discussed, but the possibility of the introduction of electric car technology was not discussed. This led to an enormous increase of the production, but that's tough luck. The other side has accepted a lump sum, and you insist on the lump sum. Is that correct?
That is correct, Mr.
Well, I mean, just arguing and not arguing, looking at this from our vantage point, as you know, I'm a German attorney, but I'm also admitted in New York. I'm a civilian. We know that the wording of the contract is a starting point, is not the end of the analysis. And there is a doctrine of changed circumstances. If the circumstances change substantially, that can have an impact on the interpretation of the contract. I don't say no matter what the wording is, but beyond the strict wording of the contract. When it gets complicated, we have Latin words. One could call that the clausula rebus sixtantibus. As civilians, you are familiar with that concept. And So that might be a difficulty for you in an arbitration, that the tribunal might say it's unfair. They looked at 100,000 and now they have 1 million and more to come. That can't be correct. Can you follow this? Have you considered that?
Well, as we stated in the opening statement, we negotiated and agreed on this specific term of the agreement, and it covers both electric cars. I think we have a strong case, but again, we do understand your point, sir, that there's the risk that the tribunal may see that there was a change in circumstances. We do see your point.
Thank you. And plus, the point I made when we were all together, intentional concealment is quite heavy. If you lose on that point, the reputational damage beyond the monetary damage would be enormous, and should be an important consideration for you to try to settle. Do you understand that?
Yes. Again, it was a confidential project, but it is also important to have a reputation in the market. So yes, we understand your point, sir.
So now I come to the proposal that Autosoft made. And as I said, there is some good news and some bad news. The good news, they are willing to settle, and they take the view that the existing license agreement should continue until 2020. If they win on the intentional concealment point, they might have an argument that that agreement be rescinded and be terminated, and that damages could follow. Point number one. Number two, for the use of the technology in electric cars, they want a per unit royalty rate of $100. And then they want you, that's the bad news, to stop using the technologies in electric cars immediately. And they don't want a renewal of the existing license agreement beyond 2020. So that's their proposal. I asked them, because I anticipated somewhat your reaction, what is in it for Cell Motor? And they say, well, it limits your financial exposure. You know how many cars you have sold. I do not know that. They have an idea, perhaps, and they know at least more than I do. But I have an idea. It's a significant amount. It's a substantial amount of money. But it's a limitation of the financial exposure. It could be more if they win in the arbitration, if they win in the Texas court, triple damages and unjust enrichment. So that is what I can bring to you on behalf of Autosoft at this point.
Thank you, Mr. Elsing, for arranging this, but we must say $100 per car would just be unacceptable. $100 per car is unreasonably expensive. We just wouldn't be able to afford that. And for the time element, it would also be a problem. We would obviously like to be using their technology for the electric cars as well. When we were outside this conference room, we were also discussing internally, and we understand the point. We believe we can compromise and agree to a running royalty, but
we could,
but
for
only
electric cars.
Yes, that is correct, sir. But only within a reasonable price.
Let me first say this is a concession on your part that you accept to move away from the lump sum idea, to pay money for the use of the technology in electric cars. That is a significant move in the direction of a compromise.
Yes. And so the big question is how much? Our proposal would be that for Cell Motor to pay for electric cars, will be $50 per car up until 2020. And for the gasoline cars, the existing arrangement goes on, meaning we'll be paying lump sum of $10 million per year for gasoline cars until 2020. And after 2020, we would like to renew the agreement, but after the 2020, we will be paying $50 per car for both gasoline cars and electric cars. That would be our proposal.
Let me just make sure that I understood this correctly. So the existing license agreement would continue with a lump sum for gasoline cars until 2020, correct?
Correct.
For electric cars, use of technology in electric cars, not $100 but $50 until 2020 per unit license fee.
Yes.
And then the new element, 5-year renewal of the license agreement, but this time for all kind of cars, $50 per unit fee.
Correct, sir.
How do you arrive at the number of $50? Is that just cut the baby in half, $100 and $50? I must explain this to the other side.
Well, when we agreed to the agreement in 2010, this technology was brand new. It was a new technology, so we agreed on the lump sum payment, but the calculation behind that was $100 per car. Now we're 2018 today. Well, it's still great technology, but it's not brand new, so we can't be paying the same amount of money as we agreed to, as we based our calculation on in 2010. And for that, we think $50 per car is a reasonable amount.
I understand that. Thank you. Thank you. And then you added another aspect, the timing aspect. You want another 5 years because the business of your company is on an upwards trajectory, and you want to continue the use for 5 years. I think I understand that. I think we make progress, and thank you very much that you have shown a very constructive attitude. So I go back to the other room now. As you see, I remain sitting here, but you come to me. In real life, that would be different. So I'm back here, and I just said when I discussed Cell Motors' offer, we are making progress. Without further ado, I just tell you what the offer is, and you give me your response. They say that the existing license agreement should continue until 2020. For electric cars, they offer, and I believe this is a very significant move, real money, $50 per unit. It's not what you had in mind, but think about the volume. It's 1 million and going upwards. You can do the calculation. It's a significant amount. I believe this is really an enormous step in the direction of a compromise. But there is another aspect, the timing aspect. For me, understandably, Cell Motor would like to continue the licensing relationship for another 5 years at the same rate per unit, no lump sum per unit, 2020 going forward, same rate of $50. Isn't that something you could live with?
I think we appreciate the concession. I think we'll have to talk internally for a moment to see if that's something we can build on.
Of course, of course.
Well, we've discussed the offer. You realize that we do believe our technology is worth $150 per car. So the offer of $50 per car is really a third of what we really believe this to be worth. But at the same time, we can appreciate that this would cover many, many more cars. In fact, internally, we've calculated that Cell Motors' market share between 2020 and 2025 probably will go up 50% from where it is right now. So that's significant in our calculation of what might be an appropriate counteroffer. So we do have a counteroffer, which is we will accept the proposal of $50 per car, meaning for the gasoline and for the electric cars.
For the extension as well?
For the extension as well.
5 years.
But we would like Cell Motor to commit to purchasing our automated drive systems to meet that predicted increase in demand of 50% between 2020 and 2025.
Let me understand. So you add now another element. You say we are making hardware, we are making devices, and you want to get Cell Motor as a new customer.
Correct. And I think that would benefit.
Want them to enter into a delivery relationship. Did I hear you correctly? For 50% of their requirement from 2020 going forward?
Correct. It would be a requirements contract.
Okay. So we defined, or I understand, the quantity under that delivery contract. How about the price?
The price would also be, well, the price for the automated driving system is something we would have to discuss. I mean, there are many ways to approach it, but our current offer, we haven't gotten that far with what the price would be.
Okay. Well, I take that to Aquasoft and see what they say. Thank you very much. We have a new situation. Aquasoft accepted your package, your offer, with regard to the license fees, with regard to the continuation of the license agreement and the amount of $50 unit fee, and the extension by 5 years with a new unit fee of $50. But there is an additional element. As you know, they produce devices, automated driving devices, and they want you to become their customer. They want from 2020 going forward that you purchase from them 50% of your requirement. 50% of your requirement. I asked them about the price arrangement, and they said, okay, they would be willing to offer a fair price. That's something they still want to think about. Perhaps the way one could deal with that, either agree to a cost-plus arrangement, and if they don't want to disclose their costs, perhaps one could agree that they do not charge more than they would charge to their other customers, so you have some assurance. What do you think? Is that something you could live with?
Let us discuss internally.
Sure.
They do make good hardware. I think that's an acceptable offer.
Is that? Okay. So you think you could actually accept that?
Yes.
That's very good news. And you really show a constructive attitude. Let me ask then Autosoft, I'm also always using the wrong word, I'm sorry, to come back. Ladies and gentlemen, I have good news. I can report that Cell Motor has accepted your offer. I also mentioned the crucial issue of the price, and I suggested that you agree on some most favored nation arrangement, that you will not charge higher prices than you charge to your other customers. So it looks like we have found a consensus. I'm very pleased, and I hope you are pleased as well. Congratulations. But we are not at the end. At the end of a mediation, even after having found a compromise, we have to see how we implement the compromise, how we bring the litigation, the arbitration, and this mediation to an end. I have prepared already a term sheet for the settlement that you just agreed. It will involve a new license agreement, gas cars, lump sum treatment, 10 million until 2020, electric cars, $50 per unit, current royalty, 5 years renewal, extension of the cooperation, but this time $50 per unit for all cars. It will involve a new delivery contract. You agree to deliver and you agree to accept delivery, to purchase 50% of your requirements of automated driving devices manufactured by Autosoft for 5 years from 2020 going forward at a best available price offered to other customers, no more. And as I said, the term would be 2020. I see from your non-verbal communication you agree with that. We have to deal with the costs incurred so far, the procedural costs, and I make the following proposal. The cost of this arbitration, which is basically my fees, which are time-based, should be shared equally. And the cost of the litigation that you started should be borne by you, and the cost of the arbitration that you started should be borne by you. Would that be acceptable?
This is acceptable to us.
Okay, so no reimbursement of legal fees, lawyers' fees. Now, you could implement this term sheet by forwarding it to the arbitral tribunal and ask the arbitral tribunal to issue a consent award. A consent award, so you would have an award that is enforceable under the New York Convention. You would not have to sue again if there was a dispute. The other alternative is that you negotiate the fine details based on my term sheet. That's basically your term sheet, which I drafted for you as a service provider. And you can implement that yourself. Perhaps it's possible to do that within 1 month. If you wanted to do that, is that possible? And the payment of the past royalties, there should be a defined payment date. Perhaps the payment, I turn in your direction, could be made within 3 months. So 2 months after the execution of the agreements.
Yes, that would be possible.
Yeah. And then, of course, the effectiveness of the agreement and the validity of the agreement would only become effective and valid once the payment of the amount is received. So that is a self-enforcing mechanism to some degree. So my question to you is, do you want to go the route of the consents award or the other route that I described?
I think we would prefer the second route. The second route.
No consent award necessary?
No consent award.
Okay. How about you?
We also think that there's no need to incur additional costs, so no consent award.
Okay. And you understand the consequences. And then I advise you that in the agreements that you agree, you should not forget to include an arbitration clause, because if there is in the future a dispute, and as a suggestion, you might even include a Med Arb clause that in case there is a dispute, which however I hope will not be the case, and I have reason to believe you have good chances that it will not be the case based on the constructive atmosphere that we have encountered today, you could include a Med Arb clause that if there is a dispute, you start with a mediation and not immediately with an arbitration, as a suggestion. Yeah. Well, with that, I again congratulate you on your settlement. I close the proceedings, not without thanking the Kyoto Mediation Center and the university here for their hospitality. And I think we all wish the Kyoto Center a very good future. Thank you very much.
はい、調停手続きの動画をご覧いただきました。まず、調停人からの挨拶と、それから割と長い手続きの説明がありました。コモンインタレストの追求が解決の鍵であると 過去の法的な争点だけではなくて、将来も含めた共通の利益、これは経済的利益に限らない。それを実現するウィンウィンの関係を構築するのだと。そのためには仲裁のマインドセットを変えろというふうに彼は言っていました。で、本件の当事者は長期の契約関係にあったことから、本件紛争も和解による解決が望ましいと考えることができる。もっとも、和解による解決に至らない場合には、仲裁に移行することも可能であるという手続きの説明。それから、この調停手続きの内容は秘密が保持されるので、率直な和解交渉を期待するということで、和解の促進を促していました。で、まずはオートソフトの冒頭陳述を行い、次にセルモーターの冒頭陳述がされました。その上で調停人が各当事者と個別に和解協議を行うという流れを確認しました。まず、オートソフトによる冒頭陳述としては、本件契約はセルモーターが販売するガソリン自動車のみを対象としており、電気自動車は対象外である。本件契約に定める固定のロイヤリティは、セルモーターのガソリン自動車の販売数の見通しのみに基づいて算出されていたのである。セルモーターは本件契約締結時に、バッテリー技術の開発と電気自動車の製造の可能性を意図的に隠蔽していたと。それから、セルモーターが電気自動車の売上に関するロイヤリティを別途支払わない場合、それは不当な利得の享受を意味するのだという主張をしました。このようにオートソフトによる冒頭陳述がなされた後、セルモーターによる冒頭陳述がなされました。セルモーターによっては、本件契約はガソリン自動車と電気自動車の両方を対象としているのだと。ライセンスとプロダクトというものはですね、いかなる自動車も対象としていることは、その定義からも明らかである。電気自動車もガソリン自動車と同様に自動車、すなわち NEV ベイクルに含まれるのだという主張。それから、セルコによる電気自動車用のバッテリー開発のプロジェクトは機密事項であったと。もっとも、セルコがセルモーターの子会社であり、セルコがバッテリー製造業者であることは高知の事実であると。オートソフトとしては、セルモーターが電気自動車の製造販売を行うことは十分に予測できたというような、法的な主張を行いました。このような両当事者による冒頭陳述を踏まえて、調停人からは、仲裁のようなマインドセットは変えろという、その趣旨に基づいて、個別のですね、包括セッション、プライベートセッションに、移行がされました。そして、まずは、調停人とオートソフト側による協議がなされました。個別の協議ですね。調停人によるオートソフトの主張の弱みの指摘もなされました。ライセンスとプロダクトという定義にはガソリン自動車に限定されてないじゃないかと。そのような指摘ですね。あるいはガソリン自動車だけではなくて、電気自動車も製造予定があったというような、その隠してた意図というものを立証するのはなかなか難しいんじゃないかというような指摘もなされていました。で、オートソフト側からの提案として、オプション1として、和解案が提示されました。セルモーターはオートソフトの特許を利用した電気自動車1台について US100 ドルを支払うと。セルモーターは今後はオートソフトの特許の利用を中止し、本契約を更新しないという提案がなされました。これは主にコモンインタレストとして、ペイメントについて、明確にする。それからタイミングとしても明確にするという趣旨にのっとってですね、オプション1が示されたというふうに考えられます。で、次に調停人とセルモーターによる協議、個別の協議がなされました。同じように調停人によるセルモーター側の主張の弱みの指摘もされました。例えば US1000 万ドルのロイヤリティが、ガソリン自動車の販売数予測のみによって算出されたという事実は、それはセルモーターも否定していないんじゃないかというような点ですね。それから仮に、電気自動車を販売するようなですね、製造するような意図があったとすれば、それは疑問というようなことになって、それはセルモーター側の大きな責任につながるというような部分もですね、これは弱みというふうに考えられます。で、オートソフト側からのオプション1の提案に対して、セルモーター側からは、ある意味、そのペイメント、それからタイミングだけではなくてビジネスも含めたですね、提案としてオプション2がなされました。セルモーターは2020年までに 同社で販売される電気自動車1台について US50 ドルを支払うこととし、上記と同一の支払い条件、電気自動車1台についても US50 ドルで本合意を5年間更新するというふうにですね、少しビジネス的な側面も含めて、タイミングも含めて、オプション2が示されたということになります。これに対して、調停人とオートソフトによる協議はもう一回、オートソフトが呼び戻されまして、個別の協議がなされました。調停人による、今申し上げたセルモーター提案の和解案オプション2の説明がなされました。これに対してオートソフト側としてはですね、やはりさらなるビジネスというインタレスト、共通のインタレストも踏まえたオプション3が示されます。セルモーターから示された和解案、電気自動車1台について US50 ドルの支払いに加えて、セルモーターは2020年から2025年までに販売される同社の電気自動車の 50% に対応する数のオートソフト社製の自動運転システムをオートソフトから購入するという提案はどうかと。この和解案によってオートソフトは自社製の自動運転システムの売り上げも伸ばして、市場におけるシェアも増やせるメリットもあると。対応して、セルモーター側にもですね、ビジネス上のインタレストを増進できるというメリットがあるという、ビジネスに踏み込んだ提案がなされたわけです。で、調停人とセルモーターによる協議がなされて、調停人によってオートソフト提案のですね、オプション3が説明されました。ここでは、ペイメント、それからタイミングだけではなくてビジネスに踏み込んで、お互い共通のインタレスト、将来に向けたビジネスについても、メリットがある提案として、こういうものが説明されて、で、セルモーターによるオプション3の受け入れが表明されたというところで、本件、和解が成立したということになります。で、これを踏まえて、最後に全員が集まってですね、両当事者との協議が行われます。この場ではタームシートをドラフト、署名して、後日より詳細な和解条項を当事者会にて作成するという方針が調停人により提案されました。また、コンセントアワードといって、和解の合意の内容をですね、あえて仲裁の判断にすると。で、仲裁の判断にすることによって執行力を担保するという方法が実務ではよく用いられるんですが、それは本件の場合、追加費用の発生を回避するために不要とされて、当事者の任意の履行というものに、期待が込められたということになります。で、この点ですね、シンガポール条約によって、調停により、和解契約に執行力が認められるという可能性も、シンガポール条約に加盟されている、管轄における、執行というものについてはあり得ます。コモンインタレスト、過去の出来事に関する法的争点についての判断、解決にとどまらないですね、共通の利益、現在進行形の関係、将来のビジネスを含めたウィンウィンの関係をファシリテートするという、これが調停人により促進されたということになります。アミカブルな解決はアミカブルな法的文化、土壌の日本、それからクロスアジアの紛争解決としてですね、非常に効果的ですので、ここに、日本をそういうアミカブルな紛争解決のプラットフォームとしてはですね、日本の明るい未来があるんじゃないかということを、最後に、申し述べたいと思います。そして、紛争解決といういわばそういうツールをですね、ある意味、外国に輸出する、すなわち第三国としての、発展可能性がですね、公正、中立、便利性という意味から、高まるのではないかということを述べまして、本件動画の締めくくりとしたいと思います。